Now I'd like to go back to incapacity planning. When planning related to your possible incapacity, you should give your powers of attorney and healthcare instructions a fresh look. For this presentation, however, I want to focus on revocable living trusts as a very important tool for protecting assets and protecting you while you're incapacitated. Over the years, my views on this topic have changed quite a bit. They've changed as the probate court system has been reformed and changed as my clients have aged. And they've changed with the number of clients we get in that have been the victims of financial elder abuse. Making a revocable living trust a part of your estate plan is a way to make sure that there are some responsible people looking in on your financial situation at a time when the frailties that come with age make you more vulnerable. A revocable trust can be a very good way of setting things up so that other people, maybe trusted family members or your accountant, lawyer, or best friend, can look in on the situation and make sure somebody knows what's going on when there's an effort being made by an unscrupulous caregiver or an unscrupulous child to basically get his hands in your pocket and take what you have for himself. Powers of attorney are too often abused because it's so easy to use them in a way that's not noticed until it's too late. So now, I'd like to take some time to explain how a revocable trust works. The thick black line on this chart symbolizes death. Before you pass away, above the black line, wills have no effect at all. The will is only effective at death. A revocable trust is established through a trust agreement. That's something you do now, while you're alive. And because it's established now, it's effective before you pass away. And it can have provisions in it that deal with lifetime issues, like your incapacity.